Hi, Glenda Back from Top Notch Legal. Now, the question that I'm addressing today is: should partners be stopped from competing with the business when they leave? Now, partners in a business have access to all sorts of valuable information. They will know who the major customers are, who the major suppliers are, how the goods and services are costed, and so on. So, if they leave the business, they have all this information that could be used to their advantage, but to the disadvantage of the business. Now, generally, a partnership agreement will take care of this sort of situation. But what's the position if you're in a company or in a trust? You might assume, that naturally they're not allowed to leave and set up in competition, but it's not the case. If they leave, they have full freedom to set up in competition with the existing business unless they've signed some sort of an agreement preventing them from doing so. And whilst I believe this is a major concern for most businesses, we have to recognise it's not a concern for every single business. Now, if it is something that concerns you, then please get help and get it worked out properly. Some people are of the belief that it's a waste of time having restraints and agreements because the courts will just not enforce them. But that's a rather sweeping statement. The courts are conservative, but so long as you can justify why you've got the restraint and the extent of your restraint, it will be enforceable. Now, I believe that for many online businesses, restraints are no longer really applicable. So they really apply to businesses that operate out of premises, say, for example, a car servicing business or some sort of health business that has to have premises. It might be really important for a member of staff not to set up in competition within a 1K radius or a 5K radius, for example. Also, it's often important to have a restraint for a certain period of time. You might want to prevent them from having access to existing customers for 6 months, or that might not be long enough. 18 months might be more appropriate. You have to consider the particular business and the market that it operates in. Now, equally, I believe that in most cases, directors and shareholders should be signing confidentiality agreements. As I said at the outset, they have access to all sorts of valuable information and they shouldn't be able to disclose that information or use it for their own advantage. So, to sum up, my own personal view is that yes, provided you have carefully worded restraints, they are certainly valuable, and combined with confidentiality agreements, they can prevent some serious damage being done to your business when a partner leaves. If you don't have these issues in place and you want to explore what you can do about it, please reach out and give us a call. We offer a 30-minute free consultation to explore what we can do for you. That's it, Glenda from Top Notch Legal.